going to recognize myself for 5 minutes. Mr. Smith, according to what you just told us in your testimony, Axon spent approximately $20 million defending its acquisition of VIEVU against the FTC, which was more than the acquisition price itself, I guess, is the way you described it. But you were willing to spend that money because you believe that every American has the right to due process. So why is due process so important to you as a business owner, having lived through it and experienced it the way you have?
This may seem cliche, but it's more important to me as an American. And I hear the passion in people's voices. There are many things we can disagree on, but I think progress can happen when we can find bedrock principles that we all agree on. The systems of checks and balances, for example, is so critical to a functioning democracy. And what I came to understand with the FTC was, in fact, there is a system that has gotten out of balance, where there is no check and balance, where there is no independent judiciary, where that agency can act as judge, jury, and prosecutor. And they presented me with a situation where they either threatened me to go into court, where there was a 0% chance over 20 years of having a fair trial where I could win, or to effectively seize my company's most valuable assets, give us an unlimited liability, and place all my 4,000 employees and all of our customers at risk. And so that's why I'm here today, as I'm now very passionate about this. I was disappointed when the FTC dropped their case against us because I felt the system was so unfair. I wanted to see it make its way back up to the Supreme Court. But when they dismissed their case, I jumped at the chance to come and testify before Congress today, because together we have an opportunity to fix the checks and balance by just simply having independent judges review every case when the government is going after an American.
Very good. Dr. McLaughlin, in a lawsuit challenging the FTC's pre-merger notification rule, business groups claim that the FTC's rule will cost over 7 times the amount that the FTC estimated in its final rule. This is kind of a consistent problem that we see. And the FTC estimates that it will cost billions. The FTC has not articulated how it will use the information to better enforce the antitrust laws. And the FTC has never articulated past examples of missed enforcement that would justify the rule. Is this type of potentially burdensome regulation that Congress, we should sit down and analyze this and potentially act on it?
Thank you. So you're referring to the new HSR rules, of course, and I did take a look at those as a reference point. The paperwork burden estimate from the FTC may indeed be low compared to what other people estimate it to be. I think it's worth pointing out that those estimates, similar to what Mr. Smith is pointing out, are produced by the same people who want to produce the rule. So maybe there's a conflict of interest there. But I would also point out that even though that paperwork burden may be what the FTC estimated or maybe 7 times larger, it still is very small compared to the overall burden of regulation. And that's my main point here. The big burden here is the totality of regulation, much more than any individual rule's consequence.
Right. Let me just follow that up. So the Separation of Powers Restoration Act, or SOPRA, would enshrine the court's rejection of Chevron deference and clarify other deferences that have allowed agencies to act as informal legislative bodies. So, and the key point is probably that SOPRA would require judges to conduct de novo review of agency statutes, the regs, the guidance documents. Can you talk about how enshrining judicial review in law may slow the pace of regulations for administrative agencies?
I think it would end up at least leaving some percentage of rules aside. And it would work like this. Agencies are going to now be aware that there's no deference anymore. No judicial deference of any sort that they can rely upon to push a rule forward. So some percentage of rules will probably just not get pushed forward at all. They will choose not to take that risk of pushing something forward that previously could have stood up because of the different deference documents. What percentage that will be, I don't know.
Yeah, I mean, the delaying factor is built into the system, which could actually, I think, assist Congress in having the time to examine and take a deeper look on some of these things before they simply become law, is the problem, right?
Yeah, and there's going to be plenty of room, hopefully, in different reforms for Congress to play a more active role. And I think that my research in the area has shown it's necessary for another set of minds to be looking at the different analyses and regulations coming out of the agencies.
Thank you.